In this video, we will talk about patent amendment. What is patent? What are the parts of an patent application? What is an extent of amenability? To what extent a patent could be amended? Whether it is pre-grant opposition or post-grant opposition? And what are the different provisions in Indian Patent Act 1970 useful for understanding patent amendment? When you file a PCT application, international application, then what are the provisions of the PCT, Patent Cooperation Treaty? Like Articles 19 we will discuss here, Article 34 we will talk about. It is strategic decision of inventors to enter into markets of Europe and US. We will see what are the equivalent position of the settled principle of law equivalent to the provisions of 57, 58 and 59. These are the sections of Indian Patent Act 1970, very relevant for patent amendment. Similarly, in European Patent Convention, you have Article 123. What are the similarities and dissimilarities or the differences between these various legal frameworks governing the patent system? We will have a view on some case laws and the settled position of law. I would try to make it simple so that it is useful for everybody, for legal fraternity, for inventors, research scientists, and patent agents too. Let us begin with the presentation. Patent specification. What are the parts of a patent specification? This is the structure of Indian patent. The US patent may differ. It will have abstract on the top and other parts of the patent in the preceding way. In our system, we have title, then there is a field of invention, background, summary, brief description of drawings are there, if any, detailed description of invention. There are claims which form the heart of a patent. Then there is abstract. Here sequence means sequence of nucleic acid that is related to genes and DNA. When you have a patent related to microbiology, biotechnology, or involving life sciences, then we have this sequence into the play. There are other treaties and other useful provisions, and it is a big concept. Then there are drawings. Now, how do we define a patent? Patent is a techno-legal document and an exclusive legal right granted by a government to an inventor or their assignee for a limited period of time. And this limited period is typically 20 years from the date of filing an application in exchange for the public disclosure of the invention. This right allows the patent holder to exclude others from making, using, selling, or importing the patented invention without permission. Quid pro quo is a fundamental principle underlying the patent system. It refers to the exchange of valuable consideration between the inventor and the public. In the context of patents, this principle will manifest as quid and quo. When we see inventor's contribution, that is quid, it is about disclosure and public benefit. This is one of the grounds where patent could be rejected or revoked. There must be disclosure. Public contribution is called quo. That is exclusive right and incentive for innovation, that is 20 years to exploit it commercially. Quid pro quo is a fundamental principle underlying the patent system. It refers to the exchange of valuable consideration between the inventor and the public. In the context of patents, principle manifests, as I told you, quid and quo. These are also sometimes called negative right or a private right. By private right, you refer that legal rights granted to an individual or entities allow them to exclude others from using their invention without permission. This contrasts with the public rights, which are rights held by the public at large. That is the reason it is called a private right. And this private right is glorifying and ascending in developed economies. One of the recent books which I read few weeks back, authored by an American economist, discusses the patent system of America, the US patent system, and its impact on economy, entire history. And he says that, he feels, the author feels that this is a private right which ascends to a democratic right in the development of an economy. This is also called, the patent system is also called a negative right, which means that a patent does not confirm an affirmative right to make, use, sell the invention. Rather, it grants the patent holder the right to prevent others from doing so. This word is very important, prevent others. This exclusionary aspect is central to the enforcement of patent rights. Patents are also intangible assets. For more information on intangible assets, I author a book called Intangibles Adapting the Transition, where I compare 50 Indian patents and analyze whether it could have been created more value if filed internationally, and what were those technologies, at which stage of product life cycle those technologies were there in the developed economies, and how it could have been helpful. You can refer that, it's available on Amazon. Now we talk about important provisions. Section 57 talks about power to amend application or complete specification. There are various type of specification depending on the type you classify. Here complete specification means when you form file 2 along with the specifications part of the patent, which we saw in a slide, patent specification. And sometimes when the research or the invention is in the life cycle, or it is not yet completed, then you can file a provisional application, and in certain period of time you have to file the complete specification. Section 57 allows applicant to make amendments to their patent application or complete specification during the patent examination process. There is section 58, which is significant from the point of view of amendment. Section 58 talks about amendment of patent and applications in proceedings before the court. To understand the differences, section 57 will talk about the patent amendment in front of the controller, that is IPO, section 58 in front of the court. Section 59 talks on the limitations of amendments of specification. 59 imposes restriction on the type of amendments that can be made to a patent specification. Amendments must be limited to disclaimers, corrections, or explanations. These I will explain you in the coming slides. There are corresponding rules you can refer, rules 81 and 82. Here one point I would like to clarify: when we talk about compare section 57 and 58, there was a change made in 2021 by abrogation of IPAB, Intellectual Property Appellate Board. The matters from the Appellate Board, when was abrogated in 21, was transferred to the High Courts. Some High Courts made special IPD, Intellectual Property Division, and some High Courts have bench to deal with it. Now, one of the think tanks in country is Delhi IPD. There are different provisions or different laws which govern the prosecution of IP in the courts. Prosecution, when we talk, it is about IPO. In patent system, Indian Patent Act, it is from section 1 to section 81 will be very significant for prosecution. Prosecution means how you apply different stages uh, during the application till the grant of the patent. There could be pre-grant opposition, there could be FER, examination report, objection raised in that, there would be replies in that. So there are different stages and it is all time-bound proceeding. So this is about prosecution. When you go to high courts or the IPD, there are different set of laws governing it. Like you have infringement matter is there, you have a patent suit rules are there, then we have commercial courts act are there, IPD rules are there. So these rules become very important. other than trademark and copyright, geographical indication. These are the different forms of IP. Patent claims. Section 10, subsection 4 says every complete specification shall disclose the best method of performing the invention, which is known to the applicant and for which he is entitled to claim protection. This is the description of patent claim in the statute. Even if you see the rules and manual, you have got and there are different 4 guidelines issued. So watching all those manuals, you try to understand patent claims. And if you this subject is quite broad, I will tell you a few types of claims. Like there is an apparatus claim. Apparatus claim defines the physical structure or configuration of a device, machine, or system. They typically specify the components, their arrangement, and how they interact to achieve a particular function or purpose. An apparatus for filling water comprising a housing, a filter cartridge located within the housing, and water inlet and outlet connected to the housing. These are some types of sentences used in framing the claim. There is very grammatically, if you evaluate the claims, it's not within the limits of a grammar. It's always better to read it as a technical understanding. And another form of claim is method or process claim. Method claim will describe a sequence of step or action performed in certain order to achieve a specific outcome or result. They are used to protect methods of doing something rather than physical structure itself. For example, it could be a method of manufacturing a semiconductor device comprising depositing of layer of silicon dioxide on a substrate, etching the silicon dioxide layer to define a pattern, and deposition of conductive material within the pattern. This could be some type of method or process claim. Then there is a use claim. Use claim describe the particular application or purpose for which an invention could be utilized. For example, you say use of compound X for the treatment of a particular therapeutic disease, that is maybe cancer considered. So a particular compound using in the treatment of particular disease could be use claim. Then there are product claims. Product claim cover specific physical items or compositions that embody the invention. These words, when you see embodiment, comprising, these have got a very special meaning in claims. They are big concepts. Then we have composition claims. Many of us know that, how to write the Marcus claim, what are its significance. There are system claims, there are sub-combination claims. System claims are there. They will talk about interconnectedness of or the elements and components that work together to perform a function or achieve result. Now the question arises, what is broad claim and what is narrow claim? And another question related to this is, can particular type of claim be considered as broad and particular type as narrow? No, it is invention specific. There is no hard and fast rule laid in manual of patents India or other patent manual and case laws and other textbooks. Rule 81, Rule 82, these are the patent rules. Recently it got amended. Not much get into rules. These are procedural aspects. You can contact me for any prosecution related work when you want to prosecute the patents. And importance of patent claim amendment. It is essential in demarcating the scope of invention. Claims determine the value of a patent. It ensures language of claim aligns with the applicant's objective. International applications by PCT route, Patent Cooperation Treaty. Here when we talk of amendment, Article 19 and Article 34, I have included one slide for each of them. Article 19, amendments to claim can be made after receiving the international search report and written opinion. up to 16 months from the priority date or 2 months after receiving the report. Then submit a complete set of amended claim in form along with a letter detailing differences from the original claim and their basis. This is very important. When you amend a claim, it is important to compare the original claim with the amended claim. What are the languages used in PCT? After amendment, there is again the patent is published. Then the claim scope for provisional protection, if not needed, opting for international preliminary examination under Article 34. India is now international search authority and an international preliminary examination also. Uh, Let me recall some case laws that will make it easier for you to understand. One of the popular case laws in Article 19 about the amendment of PCT, international application, is application of Fisher and Paykel Healthcare Limited. Uh, the invention is about a medical humidifier. You can access this patent, it's one of the best inventions. Fisher and Paykel Healthcare Limited filed an international patent application under the PCT for a medical humidifier device. This device, I will make it simple. When imagine when some patient is on ventilator, air is given for breathing. This air is to be conditioned. It has to be free from infection, bacteria. It has to achieve certain temperature, cleanliness, and certain level of humidity adapted for human body. So this was the device made. After receiving the international search report, the applicant sought to amend the claims to better define the invention. Now the issue rose to whether the proposed amendment under Article 19 were permissible if they extended beyond the original disclosure. Article 19 we saw of the PCT, which allows the applicant to amend the claims after receiving the international search report and written opinion. The IB, that is International Bureau of Patents, reviewed the amendments and determined they did not introduce any new matter beyond the original disclosure. The amendments clarified that the invention were accompanied by detailed letter explaining the changes which were made in the original application. These amendments were accepted. Another very popular case law is about Nokia communication device. Nokia filed an international application for a communication device that is mobile, sought to amend the claims. Now the issue rose to whether the late filed amendments under Article 19 could be accepted by International Bureau. There is timelines we saw given in Article 19 and they were late in submitting the application. Article 19 provides a specific time frame for filing amendments, but the PCT allows for flexibility if amendments are received before the technical preparations for publication are completed. The IB accepted the late amendments as they were received from the completion of technical preparations for publication. The amendment did not introduce new matter and were accompanied by a detailed letter which explained the changes, the amendments. As I told, it has to be compared, the original claims and the amendments, and there has to be clarification. This case is important because it shows the procedural flexibility in accepting the late amendments. Now, under Article 34, if you amend a patent, what are the conditions and what are the limitations? File replacement sheet for an amended part, accompanied by a letter which explains differences and basis for amendment. The languages in international application. Failure to provide a letter with replacement sheet may result in amendment not being considered during international preliminary examination. Compliance with amendment rule is important. for acceptance by designated National Patent Office. The international applications during prosecution, you enter the national phase. So the last line mentions that. Here, to understand it better, I will uh, recall Chevron Phillips Chemical Company. The invention is about the case law. Invention is about olefin polymerization process. Olefin is a type of organic compound, and polymerizing means making bigger molecules from combining the monomers. That's called polymerization. Now, the Chevron Phillips Chemical Company filed an international patent application via PCT route for this olefin polymerization process. And during the international preliminary examination phase, the applicant requested amendments under the uh, for the claims that was under Article 34. Now, the question arose whether the amendment complied with the requirements of Article 34 and subsequent rules. I think Rule 66 is important here. You can refer, I'm talking about PCT rules, specifically regarding new matter and clarity. So, introduction of new matter is not allowed, and it is always said that the patent language should be clear and concise. So now the Article 34 uh, 2B of the PCT that allows for the amendment to the claims and to the descriptions to the drawings and the international preliminary examination during the examination. So Rule 66 outlines the procedural requirement for such amendments, and these amendments were accepted because there was no new matter introduced, and the accompanying letter explained clearly the basis of amendment. That was the reason they were accepted. Now you have another interesting case law in this section, Article 34, when you file a PCT application. It is about Sony Corporation's electronic display device. This display device will have lot many patents if you explore the patent database. Here, Sony Corporation filed an international patent application for an electronic display device and later amended its claim under Article 34. The amendments were again accompanied by some detailed letter which explained the changes and the basis of change. The issue in this application was whether the amendment met the formal requirements of Article 34 and Rule 66 of the PCT if they introduced new matter. Then, if you analyze Article 34 and Rule 66, that requires amendment must not introduce new matter and must be accompanied by a letter explaining the changes. The International Preliminary Examining Authority (IPEA), they reviewed the amendments and confirmed they did not introduce a new matter. So this is how you understand the importance of Article 34 when you want to amend the application during the examination process. Even in this Article 34, you can remember an important case law called BioWell Corporation that was for controlled release pharmaceutical formulation. Controlled release or delayed release is a kind of technology used in medicines or drugs, wherein the patient takes the drugs and the release of that drug is over a long period of time, which helps to maintain the peak levels in the blood for longer time. This might be useful in certain disorders. So the invention was related to that, and BioWell Corporation was the applicant. So the applicant submitted the substantial amendment. Substantial means major amendments to the claim under Article 34. And there has to be always a detailed scrutiny before the amendments are accepted. Now, the issue here in this case of controlled release pharmaceutical formulation was that the substantial nature of the amendment, which required additional scrutiny or opposition if they introduced a new matter. The International Preliminary Examination Authority conducted a thorough review of the amendment and confirmed they did not introduce new matter. The detailed accompanying letter provided a sufficient basis for changes ensuring compliance with procedural requirement. The amendments clarified the claims were accepted after rigorous examination. So, rigorous examination, here you have to remember doctrine of plausibility. It is much more than doctor of possibility, not just a legal conclusion, but based on scientific evaluation of the facts. Remember these two articles. If you have an international application for amendment, I have experience in executing that. Let us understand procedure in India. It is when even the international application entering the national phase, we have to follow the procedure. Then there is a limitation on claim amendments. Like you have a limitation in amenability of a constitution. You cannot distort the basic structure. Similarly, here you cannot go beyond the scope of the original claims of your application. That is, amendment must not expand the scope of original claims. Allowability assessed by the controller, and claims must fall within the scope of pre-amendment claims. Need for amendments. To bring clarity into the claims, to overcome objections raised by IPO, people want to amend the claims most of the time for this reason, because there are objections raised by the patent system. To conform with the requirement of the Act, to clearly define commercial aspects claimed in the invention. This is by, there are various methods by which amendment could be done: by disclaimers, by clarification, by correction. So, to bring the consistency at various jurisdictions. Legal basis for amendment. In India, we have Patents Act 1970. The Section 57 allows voluntary amendment or in response to objections. Amendments can be made before or after the patent is granted. Section 58 talks that amendment during legal suits challenging patent validity. That is Section 57. For simple, for simplicity, you can remember this way. Section 57 is about amending in front of the controller. Section 58 in front of the court. Here you can recall very important case law, Anarchon versus, Alois Woben. Anarchon sought to amend the claim in its patent application, which was related to wind turbine technology. Wind turbine means there are fans, big fans, which rotate, or revolve with the air currents. And then there are magnetic fields related to that. That is, the motion is converted into electrical energy. This is called wind turbine technology. And the invention was about that. The amendment aimed to narrow the scope of the claim after a pre-grant opposition by Alois Woben. Alois Woben is a company into the same domains, and if you let us not keep the scope of technical comparison in this presentation, it will elongate much, because we have 40 slides already here to talk. But that was an interesting invention in the domains of science. The issue arose here was whether the amendment to the claims were permissible under Indian patent law, that is Indian Patent Act 1970, whether they introduced new matter or expanded the scope of original claims. The design of this turbine is very important. If you see the amendment of claim in comparison, then let us understand Section 57, which we saw in the previous slides, which allows amendment to be made to a patent application or a complete specification with the approval of the controller. The court ruled that the amendments were possible as they did not introduce new matter and were intended to clarify and narrow the scope of the claims rather than expanding them. See, one can narrow the claim, but they cannot expand. The legal doctrine beyond that, when you try to expand the claim, comparing it to the original application, you are infringing, or you are trying to enter the third party's right. That is the very gist of this legal system. These amendments were found to comply Section 57, and it was allowed. Another important case law in this topic is about Section 57. 58 and 59, let us recall, it is about Bayer Corporation versus Union of India. Bayer is a company which filed a pharmaceutical application and post grant to align with its amendment to align with its European patent. Then NATCO challenged it. NATCO is a pharmaceutical company. The issue was that whether post-grant amendments that align claims with those in corresponding foreign patents are permissible and whether they introduce new matter. Now, here we see and analyze and see the applicability of Section 58 and 59. Important precedents were laid in this judgment. This 58 and 59 section allows for the post-grant amendments, provided they do not add new matter or extend the scope of the original claims. Now, the court analyzed that these amendments aligning claims with foreign patents are permissible as long as they do not introduce new matter or extend the scope of the original claims. Bayer's amendment were found to comply and it was accepted, it was allowed. Another case law, if you want to see, this amendment is one of the most evolving evolving space of law. Another is Novartis AG and Union of India. Here also there is a good precedent coming out for Section 59 and 57 and how they interplay. When clarification was based on original disclosure determining the permissibility of the amendment. This invention was about crystalline form of active ingredient used in the pharmaceutical. These are some important case laws wherein you see the interplay of Section 58 and 59, 57 about amendment. Conditions of amendment. Section 59 lays down the limitations for the amendment. It also says that amendment could be done by or allowed by disclaimer, correction, clarification, and explanation. Amendments must incorporate the actual facts. No new matter allowed beyond the original specification. Amended claim must fall within the scope of the original claim. These are some important points and takeaways from this section. Permissible claim amendment. Amendment should enhance clarity and precision, must adhere strictly to the conditions stipulated in Section 59, essential to avoid adding new subject matter not originally disclosed in the patent application. When you amend by disclaimer way, then adding new feature or clauses to narrow claim scope. You are claiming, you have already claimed in the patent application, there is a claim which sets the rights and boundaries of your rights of the invention. Then you want to disclaim it. Disclaiming means doing away with the claim, narrowing it down. Merging or deleting claims, this could be the type, and useful for overcoming objections. When there is an objection, if you see the FER and analyze it in the field of biotechnology, in the field of microbiology, and other embryonic sources related to life sciences, and you will find these types of amendment by disclosure, disclaimer becomes important. Another question, if you have a sequence like nucleotide and nucleoside parts of DNA, then what is the conditions and limitations of amendment? Let me know. I have worked with certain international patents in these domains. Considerations for disclaimer. Deletion of claims must be cautious. What is not claimed is disclaimed. Impact on filing. Divisional applications. Divisional applications would make another video for divisional application and how to amend it. What are the differences between priority date and filing a divisional application and amendment henceforth. These are important questions which makes the subject more complex, so it's better to have a new presentation. Let me know in the comment of this. I will be posting this video in YouTube and social media. Amendment by correction. If you do amendment by correction, there is clerical or typographical errors. This could also be corrected by the controller. Most must not alter the function or scope of the original claims. This was in Anerkan versus Alois Wopen. Correction was rejected for altering the scope. One cannot alter the scope by amendment. Then there is amendment by clarification. Provides clarification to the claim. Sometimes in computer related invention, I have seen very good inventions. They don't provide clarity and they are objected in FERs. And it is important when you write claim for CRI, that is computer related invention, it is the skills are required in that specific domain. And this amendment by clarification ensures claims are clear and precise. In allergopharmaceuticals, clarification led to broader claim and was rejected because it violated section 59. This is important, you can remember allergopharmaceuticals. Specifications must support amendment. Amendment must be supported by the original specification. Some case law in this area is AGC Flat Glass Europe versus Anand Mahajan. Limitations from description were allowed limitations from description allowed if scope is not altered. If the scope is altered, the amendment will not be allowed. Altering the scope is one of the grounds for rejection of amendment. Introduction of news, there are certain grounds which we can discuss later, and it is case to case basis. Drawings can show support for amendments. Prism Cement versus Controller of Patents and Designs. Similarly, in the area of biotechnology, you have settled position. What are the sequences, how it could be amended, and how it can show support for your amendment is a skill. Scope limitations, as discussed in section 59, amendments must not expand the original claim scope. This is a new case law, Nippon AL, much discussed and much uh, discussed about. So this is in this matter, the product by process claim uh, were amended to process claim, and it was allowed. There was some confusion among the experts that section 59 uh, was, less appreciated in this matter, but the court has given very good order, over the controller's order. Use claim versus method claim. Use claim cannot be amended to method claim. This was held in one of the patent application. Then triggering divisional application. Claims in divisional applications must be based on parent application claims. And here the important case law is Boehringer Ingelheim International, where voluntary amendments were not taken on record because of the divisional application. Dependent claims, there are claims which are independent. Usually the first principal claim is independent claim always, and there are dependent claims. These dependent claims are depending on independent claims. Again, these dependent claims get into the micro levels of the invention or the feature or the claims. Adding dependent claim does not expand claim scope. Dependent claim should not expand the claim scope. Tony George, the reagents of the University of Michigan versus Controller of Patents and Design. This is interesting case law during the lockdown period. You can have that. Amendments in revocation proceeding allowed at court's discretion during validity challenges. When the validity of a patent is challenged, amendment is allowed. Conduct of patentee and delay in seeking amendment are critical here. This was held in AGC Flat Glass Europe versus Anand Mahajan. Unjustifiable delay in amendment is a ground for refusal. As I told you that Nippon case law is very important. Delhi High Court set aside the controller's order refusing the patent application of Nippon. That was an international PCT application and one of the most complex applications. If you go through, it will make all your concepts clear. Controller rejected this application due to claim amendments altering scope, which was violating section 59(1) of the Patents Act. Here we will also try to understand how the Article 123, it's equivalent article in European Patent Convention, interfaces or what are the similarities between Section 59 and Article 123 of the European Patent Convention. When I say Section 59 is about Patent Act 1970, Indian Act. There was a divergent judicial view on the permissibility of the scope of the claim amendment, which led to significant, impact on the patent law and how it is interpreted. There are other two case laws in this domain. You can see Boehringer Ingelheim and Allergan. In Allergan, the doctrine of purposive interpretation was evolved in this. What it means is that it is a kind of judicial approach that seeks to understand and apply the law by considering its underlying purpose and intent. It promotes justice, fairness, and flexibility, ensuring that the law remains relevant and effective in addressing contemporary issues. Contemporary issues means the issues at hand, at present, whatever the matter is. This method contrasts with the strict literal interpretation provided in the holistic understanding, may be provided in the legislative texts. There are golden rules for this purposive interpretation, and these were taken into consideration. And consistency and predictability was also taken into evaluation of these claims. And then, this is important case law for amendment. Key sections, as I told you, there is a equivalent section in European Convention and section 59 of Indian Patent Act. Let us see how we compare it. No amendment of an application for a patent or a complete specification or any document relating thereto shall be made except by the way of disclaimer, correction, or explanation. These three way of amendment we saw in the previous slide in detail. Amendments must not claim or describe matter not disclosed in the original specification. Amended claim must fall wholly within the scope of original claims. So what this slide means, let us compare section 59 and article 123 of the European Patent Convention. There are certain similarities in these two. Similarity is like if you have left hand side and right hand side comparing both the statutes or the provisions of different statutes governing the patent system internationally, you find the similarities. The similarity is, first is, I can say that there is a prohibition of extending beyond original disclosure. We saw section 59(1) strictly lays down that you cannot extend beyond the original disclosure. Similarly, article 123 of EPC prohibit amendments that could add new matter which was not originally disclosed in the original application. This ensures that the amendments are restricted to what was initially filed and prevents application from expanding their claims beyond what was originally disclosed. Second similarity, you can say that it is about scope of claims. Both Indian Patent Act 1970 section 59 and article 123 of EPC, they both say that no amendment claim shall fall outside the scope of the original claims. Then they talk about procedure. There is similarity between the procedure. Here we file certain form. Even if you see the European Patent Manual, you get those kind of forms. Now let us see the differences. What was much important, what became much important in Nippon matter. Few experts wanted to say that the interpretation of IPO was better, and some experts take the side of court. I am no expert to have, but I will go with the court's opinion because one of the important doctrine which was laid down, or explicitly, not implicitly, I mean it was not expressed, vice versa. But the differences lies in the type of amendment allowed. We saw there are various types. That was just for your understanding, I gave the type, but the types of claim could be much larger in number. And the another question which might come to your mind, whether you can have a mixed claims. Yes, you can have a mixed claim, and claims are, not just the question of fact. It is question of law. It is either a mixed, more of a mixed question of law and fact. Here again, the doctrine of plausibility becomes important in understanding. So one of the differences which I point out is the type of amendment. Section 59(1) mentions that amendment can be made by way of disclaimer correction and explanation for the incorporation of actual facts, whereas Article 123 of EPC does not specify the types of allowable amendments in its text, but refers the implementing regulations for details. Right, so it is much broader in scope, I would say. Amendment, because when you say that by the way of disclaimer correction and explanation, or mention that certain conversion of certain type of claim into another type makes it broader or narrower, then the question arises, is there any matrix which says that the breadth of this particular, there has to be prior art to refer this, and it has to be case to case basis. Second difference you can point is about amendment considerations. Indian provision 59 includes the interest of the applicant and the public when allowing the amendment, and EPC article 123 does not mention such considerations. And there are certain differences in the post-grant amendments. If you see the present European system of unified codes and Indian system that is now a two-tier system from IPO to high courts, then there is certainly post-grant amendments. There are certainly differences, and there are different laws in which you can patent suits law is one of the IPD rules. You can see the differences. Claim versus specification. This is not a legal concept as such, but for your understanding, I have included this. Specification means Form 2, entire main part of the patent application, I would say. And claims are part of specification, which forms the breadth of the legal right. So let's go to another slide. Section 59(1), limitations on claim amendments. Amended claim must not claim matter not disclosed in the specification. Amended claim must fall wholly within the scope of the original claim. Mathematically, the amendment must be subset of the original claim. A review requires comparison of claim before and after amendment in addition to the original specification. Now, there was a lot of articles coming on Nippon and experts write various views on that. Even I may blog certain things if I get time. But here the main issue was product by process claim amended to process claim. Now the controller rejected this amendment citing change in claim scope. Honorable High Court of Delhi IPD allowed the amendment, viewing it as a disclaimer. So, in Delhi High Court judgment, you will find very good doctrine and explanation for this, and it is housed to certain legal doctrine of claim. European Technical Board of Appeal, like we had a three-tier system before 21, there is a appellate board. Court relied, there is another matter of Konica sensitizing decision under Article 123 of APC, and there are differences which I told you in the previous slide. And Konica will discuss this technology as such, and because without understanding the technology, it would be difficult for you to understand the claim. And we will analyze how Konica's applicability to Indian law would be limited in a specific context, and this becomes very important to Indian context and European context, both wherein the Konica does not allow universally product by process to process claim amendment. Also, the equivalent case of Nippon judgment, which emphasizes the importance of a strict adherence to 59(1) when the prosecution of at national phase, and the reversal of it in the Honorable High Court gives a broader interpretation view. Here, when we see the things get broader, then the patent law, all the laws emanate from Constitution. That's true, but there was an Iyengar committee report which gave the physical framework of how this law should be, and here the court cited this report. It is, you can download it, one of the best reports you come across. And there are certain paragraphs which are important when you see the amendment. Paragraph 553 to 555, these three paragraphs emphasize the wider amendment scope for the acceptance. That is what the analogous, the same decision was given by European Court, but the narrow interpretation of Section 59 was broadened, taking this committee report in view. Now, these are some excerpts from the extracts from the Iyengar Committee report for your understanding. The scope of an amendment before acceptance ought to be wider than that after acceptance. After acceptance of the application, the right of the third party should be taken into account. A mere shifting of the center of gravity ought not to preclude means to limit an applicant, limit or stop an applicant from adjusting that center until the specification is accepted. Here it becomes important for, if you are drafting a patent claim, it is important to understand that keep it as broad that it doesn't go bad. Broaden it to a limit because most of the broad claim go bad in law, and narrow claims will certainly, you will find it difficult when you approach for amendment of this application. Now, it is important because some critics, they talk about precedents and report. So I wanted to compare this slide. See, for those inventors watching my video will find it useful. Lawyers already know what the precedent is and what are the differences between a precedent and a report. Precedent in the context of law refers to a legal principle or a rule established in a court decision, and it is followed by the subsequent courts in similar kind of cases. It is a fundamental concept of common law system. You call it common law legal systems. You might have heard of India is a common law country. UK is Canada, Australia, where judicial decisions form an important source of the law. Then there are certain key aspects when we talk of precedent. We need to understand these are found in the case laws, and the precedents set by the higher courts such as appellate court or supreme court within a particular jurisdiction are binding on the lower courts within the same jurisdiction. This means that lower court must follow the legal principles established in the higher court decisions when the facts and issues of the case are substantially similar. This also arises if you try to read an article. There is a term that mentions stare decisis. Latin for this term, that is stare decisis, is to stand by things already decided. It is a kind of doctrine that courts adhere to precedent and not disturb settled matters. This principle provides stability, predictability, and consistency to the application of law. Then there is certain hierarchy for following these precedents, and certainly these precedents have legal certainty and judicial efficiency. So, legislative context of the publication. Specifications are not published before Section 143 talks. Specifications not published before acceptance. Publication marks the point when third-party rights are considered. Amendments post-publication should be limited to safeguard third-party interest. Then we already interpreted this. Section 59 sets the limits, and there are certain inquiries which are to be met while the process of amendment goes on. This is about Nippon, and we already concluded it. So these were the slides which we had, and I'm sure that you found this slide useful. Thank you for watching my video, and if you need any more information on the subjects related to intellectual property, that is patents, trademarks, copyright, let me know, and I'm available for consulting and patent prosecution, international and national applications as well. Thank you for watching my video.